Good morning. This is Rajeshkumar. Today we are going to analyze one problem question on misrepresentation. The video content has been made available for informational and educational purpose only. Kindly go through it. Let's start with the problem question. Boris, an eccentric old man, he collects the antique carpets. He realizes he may soon lose his job and so decides to sell some of his collection. He emails Carrie, a dealer in antique carpets, and sends her a picture of the carpet he wants to sell, which he describes as an 11th century Persian carpet measuring 3 by 3 meters. Carrie is very excited as the square carpets from that era are very rare, and she immediately phones Boris. Carrie explained to Boris that the carpet will be much less valuable if it has been repaired, and Boris assured her that it never been repaired. Carrie agrees to buy the carpet for £20,000 and she will collect it next week. When Boris is rolling up the carpet for Carrie to collect, he notices for the first time a large repair to the underside of the carpet. When Carrie comes to collect the carpet, Boris asks if she wants him to unroll the carpet so she can see the design, but Carrie replies that the picture was enough. She pays Boris in cash and takes the rolled up carpet away. Carrie displays the carpet in her shop and is very surprised when it fails to sell. 3 months after buying the carpet, Carrie inspects it closely, including the underside, and sees the repair. She realizes that with the repair, its value is only £5,000. She is especially annoyed as shortly after she bought the carpet from Boris, she was very surprised to be offered an identical carpet in unrepaired condition for the same price as she paid Boris, but declined to buy it as she had already spent all her spare money on the Boris carpets. The other carpet was sent to auction by its owner, where it sold for £30,000. So we have to advise Carrie as to any liability and remedies she may pursue for a misrepresentation against Boris. This scenario raises issues of misrepresentation contract law, focusing on Boris' assurance about the condition of the antique carpet. The potential remedies available to Carrie. A misrepresentation occurs when an untrue statement of fact induces a party to enter a contract. Here, both express and implied statement may constitute a misrepresentation. Was there an actionable misrepresentation? The untrue statement of fact. Boris' assurance that the carpet had never been repaired constitute an express untrue statement. Carey specifically emphasized the importance of an unrepaired carpet for her valuation, and Boris' statement directly influenced her decision to purchase it. In Horsfall versus Thomas case, held that concealing a defect may imply misrepresentation if it affects the buyer's decision. Although Carey did not inspect the carpet and the site, under the Redgrave versus Horde, the availability of inspection does not negate the impact of an untrue statement. Additionally, Boris rolled up the carpet, concealing the repair, which could imply he was aware of the repair's impact on the carpet value. His failure to disclose this defect may be seen as an continuing misrepresentation, as outlined in Bit versus Wolflagen, where a party who later discovered a defect must correct their initial representation. So Boris' omission of the repair's discovery could thus render him liable. Inducement. Carey relied on Boris' statement when purchasing the carpet, indicating the inducement. The fact that Carey immediately acted on his assurance without inspecting the underside further supports that she entered the contract based on his word. This reliance establishes the causation, allowing Carey to claim a misrepresentation. So, to conclude, Boris' untrue statement about the corporate condition constitute actionable misrepresentation as it directly induced Carey to enter the contract. State of mind and fraudulent misrepresentation. For the misrepresentation to be fraudulent, the defendant must knowingly or recklessly make a false statement. In Derry vs. Peak case in 1889, the court held that the fraudulent misrepresentation requires intent to deceive or reckless disregard for truth. When Boris initially stated that the carpet had not been repaired, he may not have known about the defect, suggesting a negligence rather than fraud. However, upon discovering the repair, Boris still chose not to disclose it to Carey. This omission, in light of his earlier statement, could demonstrate a reckless disregard, potentially elevating his contract to fraud. Alternatively, if Boris' assurance was negligent, under the Section 2(1) of Misrepresentation Act 1967 allows for liability without proof of intent to deceive. Under the Roy Scott versus Rogerson in 1991, damages for negligent misrepresentation under the Section 2(1) are assessed as if the statement were fraudulent, allowing Carey to claim a broad range of damages. Even if Boris lacked knowledge of the repair when initially making the statement, his later failure to disclose it could support a claim for negligent misrepresentation. In other words, the fraudulent misrepresentation occurs when a false statement is made knowingly without belief in its truth or recklessly as to whether it is true or false, based on a Derrick versus Peake in 1889 case. Here, Boris initially assured Carey that the carpet had not been repaired, likely believing it was true at the time. However, when he discovered the repair while rolling up the carpet and did not disclose it, his continued silence could constitute a fraudulent misrepresentation. In Witnesses O'Flagon case in 1936, the court held that if a party makes a statement that was true when made but becomes false later, they have a duty to correct it. Boris' failure to disclose the repair after discovering it could be considering as a continuing misrepresentation as seen in Aprila versus Spice Girls Limited case in 2002, where the failure to disclose changes affecting a prior representation was deemed a misrepresentation. What is Boris' state of mind? At the time of his initial statement, Boris might have been acting negligently, but once he discovered the repair and failed to inform Carey, his conduct shifted towards fraudulent misrepresentation. Carey could argue that Boris knowingly allowed her to purchase a carpet under the false pretenses, constituting a fraud. A negligent misrepresentation under the Section 2(1) of the Misrepresentation Act 1967 applies when a party makes a false statement of the fact without taking reasonable care to ensure its truth. The Act shifts the burden of proof onto the representative to prove that they had a reasonable grounds to believe the statement was true. Boris could be liable under this section because he made the assurance about the carpet without checking it carefully beforehand. So the Boris statement that the carpet had never been repaired without thoroughly inspecting it could be considered as negligent. He failed to take a reasonable care in verifying the accuracy of the statement, making him liable under the section 2(1). The innocent misrepresentation occurs when a false statement is made with a reasonable belief that it is true. If Boris honestly believed the carpet had not been repaired when he made the statement and did not discover the repair until after the contract was performed, this could be a case of innocent misrepresentation. However, once Boris became aware of the repair and failed to disclose it, the misrepresentation could no longer be classified as innocent. The Carrie's reliance on the misrepresentation. To succeed in her claim, a Carrie must show that she relied on the misrepresentation, that it induced her to enter into the contract. Carrie made it clear to Boris that the carpet would be much less valuable if it had been repaired. Boris' assurance was a critical factor in her decision to buy the carpet, and subsequent discovery of the repair significantly reduced the value of the carpet, which demonstrates inducement. Whereas in the Hospital versus Thomas case in 1862, supports the argument that concealment of a defect, even if the buyer does not inspect the goods, constitute a misrepresentation. Although Carey did not inspect the underside of the carpet before purchase, this does not bar her claim. In Redgrave versus Heard case in 1881, the court held that a party is not obliged to investigate or verify the truth of a statement, and reliance on the misrepresentation is enough to succeed in a claim. What about the liabilities under Section 2(1) of the Misrepresentation Act 1967? Under the Section 2(1), if Carey proves that the misrepresentation induced her to enter the contract, Boris would be liable unless he can prove that he had a reasonable grounds for believing the statement was true. Given that Boris discovered the repair before handing over the carpet, he would likely struggle to show a reasonable grounds for his continued silence, which would make him liable under the Act. In other words, under Redgrave versus Horde case, the Boris' failure to disclose this material fact qualifies as misrepresentation, as Carey relied on his assertion and did not examine the underside due to his reassurances. Carey can argue that the Boris' conduct in rolling up the carpet to hide the repair implies the intent, akin to Horsfell versus Thomas case, where a concealment constituted a misrepresentation by context. This supports her case that Boris misrepresented the carpet's condition, inducing her to pay £20,000. Boris' misrepresentation may initially appear as negligent, as he did not verify the corporate condition before making the statement. However, once he discovered the repair, his failure to inform Carey could elevate his action to fraudulent misrepresentation, as he knew of the repair but chose to conceal it. With versus Flogan case confirms that a party must disclose any material change before the contract finalization. Boris' silence breached his duty. For the claims under the Section 2(1) of the Misrepresentation Act 1967, the carry would argue that Boris lacked reasonable grounds for his statement, thereby establishing the liability for negligent misrepresentation if his action fall short or fraud. So, what are the remedies for misrepresentation? The first one is a rescission. Rescission restore the parties to their original position, voiding the contract. Carey would be entitled to return the carpet for a full refund. However, rescission may be barred by lapse of time, as in Lee versus International Galleries in 1950 case, where 5 years elapsed before the misrepresentation was discovered. Here, in our case, it's only 3 months have passed, so a lapse of time may not bar the rescission. Additionally, the fraudulent misrepresentation removes the lapse of time bar as confirmed in Salt versus Statstone Specialist Limited case in 2015. If Boris' misrepresentation is deemed fraudulent, carries right to resign would remain intact. So the second one is indemnities and damages under the Section 21 of Misrepresentation Act 1967. Carrie may seek damages for losses directly arising from the misrepresentation under the Section 21, which provides damages as if the misrepresentation were fraudulent. In Roy Scott versus Rogerson case, the damages were awarded based on tort principle, enabling the recovery for all the losses directly related to misrepresentation. Here, Clary can claim the £15,000 difference between the paid price of £20,000 and the actual value of £5,000. So, what are the additional damages for the lost opportunity? Carrie declined a chance to purchase a similar but unrepaired carpet for £20,000 due to her reliance on Boris' misrepresentation. In East versus Maru case in 1991, the court allowed damages for the lost profit resulting from a misrepresentation. So, the carry may argue that Boris' misrepresentation caused her to miss this alternative opportunity by justifying a claim for £30,000, the value of the unrepaired carpet at auction. So we are moving to the last one, damages under the Section 22 for the loss of bargain. Alternatively, Section 22 of the Misrepresentation Act 1967 provides damages instead of rescission if the court finds that a rescission is not suitable, while Section 22 cannot be invoked in cases of fraudulent misrepresentation. It remains an option if Boris' conduct is deemed merely a negligent. This remedy would compensate Carrie for her lost bargain, potentially awarding her the difference in the value between the defective and the alternative carpets. If Carrie establishes the fraudulent misrepresentation, the lapse of time does not bar the rescission, as per the Salt versus Statstone Specialist Limited in 2015. Furthermore, under the Section 22 of the Misrepresentation Act, which allows the court to award damages in lieu of rescission, so does not apply in cases of fraud. So the carrier's right to resign remains intact. In other words, a carry can also claim damages for the losses incurred due to misrepresentation. Under the Section 2.1 of the damages are awarded on a tortuous basis, which means a carry is entitled to be put in the position she would have been in had the misrepresentation not occurred. In Royscott versus Trust Limited versus Rogerson case in 1991, the court applied a tort-like measure of damages under the Section 2.1 holding that the measure of a negligent misrepresentation is the same as for the fraud. Whether a carry is entitled to the indemnity? Yes. A carry may also be entitled to indemnity for any cost directly related to the purchase, such as transportation or marketing expenses associated with the corporate. However, this remedy would not cover the loss in value or the lost profit. Let's conclude. So Boris is liable for misrepresentation as his false assurances induce the carry to buy the corporate. This misrepresentation may be classified as negligent or potentially fraudulent due to Boris' failure to disclose the repair upon discovering it. Carrie can seek a rescission, returning the carpet for a full refund. If rescission is unavailable, she may claim damages under the Section 2 of the Misrepresentation Act, including the £15,000 a loss in value and possibly the 30,000 opportunity cost. If the court finds a Boris conduct negligent, the damages may also be pursued under Section 22 as an alternative to rescission. Thank you.